I'm Abdirazak, advocate, acting for Professor Anangwe in a matter where we have petitioned the University of Nairobi, Ministry of Education, and the Attorney General. We have got a relief and orders reinstating Professor Anangwe as the chair of the Council for University of Nairobi. It is a day for the Prof that the evils have been couldn't have their way and their day, and the professor is now back to work. This was after the professor has done numerous correspondence with anti-corruption, EACC, and the same cartels are the ones who don't want the Prof to continue by doing the good work that he was doing at the University of Nairobi.
As you are all aware, Mr. Julius Ogamba, the CS Education, purportedly revoked my appointment as the chairperson of the University Council via the Gazette Notice number 1957, dated 21st of February 2025. I had been appointed earlier as the chair of the council as per Gazette Notice number 67 of 22nd May 2023 for a period of 3 years. So this revocation was meant to cut short my term of office by 14 months, and that is the crux of the matter. That is the crux of this particular legal contention. The grounds have already been stipulated upon which the office of the chair of the council or any other council matter, council member can be vacated. They are very clear and they have been laid before the court. Initially, I contemplated of letting the matter rest, but 3 factors prompted me to seek redress in a court of law. 1, to let Kenyans know the revocation was an unlawful step by the cabinet secretary, and the previous cabinet secretaries have always lost in court whenever they have attempted to do so, because the University Act does not empower a cabinet secretary to revoke the appointment of a council member or the council chair before the term of office lapses. Before the term of office lapses. So in my case, my term had not lapsed. I didn't warrant that particular action being taken against me. The second factor that motivated me to seek court redress, I felt maligned by the purported revocation as if I had failed the good governance test. I have a duty to safeguard my reputation by having the matter settled in court, to set the record straight, and to avoid leaving any room for speculation on what happened to warrant such a drastic action. And the third factor that motivated me to seek legal redress, currently the university is in dire straits. Many have said that there is a risk of it going under. It is real. It has huge debts amounting to billions of shillings, which began with a trend when the government started not meeting its obligations to universities in terms of capitation. The University of Nairobi previously used to get 80% of its budget from the government. Then gradually, under the arrangement, the funding model earlier on, it declined. The capitation declined to less than 50%. And that has been the trend And when this happens, of course, it will have consequences on the capacity, financial capacity of a university to meet its financial obligations. So it is not the right moment to run away from such a monumental challenge, and I believe it is possible to get back the university to its feet. We were already mooting arrangements, plans, and they are all known amongst the council members, and this is the agenda that we wish to continue to pursue to get back the university to its feet. I firmly believe that accountability and transparency would be the sound basis of good governance. It is both troubling and shameful that UASA has opted to portray itself as a victim, while the reality indicates that they have played an active role in corruption, in abuse of office. Indeed, the treasurer of UASA is one of the people whose names have been forwarded to EACC, having looted nearly 20 million shillings as an individual.